Good morning, everybody, and thanks for joining our Virginia Solar and Energy Storage 2021 Legislative Update webinar, presented by the Renewable Energy team at Williams-Mullen. I'm Brad Nowak, partner and co-chair of Williams-Mullen's Renewable Energy practice. I'm based in our Washington, D.C. office. I'm also pleased to be joined this morning by Patrick Cushing. Patrick is a partner and vice chair of Williams-Mullen's Government Relations Group and is based in a Richmond, Virginia office. He's an attorney and seasoned state lobbyist with extensive experience in crafting policy and advocating for a variety of issues before the Virginia General Assembly. In the area of renewable energy, Patrick has extensive experience lobbying for renewable energy developers, associations, and other clients on solar, wind, and other renewable energy policy matters. He is also very involved with various stakeholder groups such as energy storage and facilitating direct communication with key agency officials, governor's administration, and members of the General Assembly. Before we begin our program, I have just a few housekeeping matters to go over. At any point during the presentation, you may submit questions by using the question button located on the lower part of your screen. We'll answer those questions at the end of the presentation, and if we don't have time, we'll reach out afterward. Also, if you're having any audio or technical problems, please use that same question button and we'll help resolve. Finally, today's PowerPoint presentation will be emailed to everybody following today's webinar. Before we pass the program to Patrick, I just want to do a quick rundown on today's program. We'll begin with a brief snapshot of the 2021 General Assembly session, just to give some context and describe the current legislative climate this year. And for those new to Virginia, we'll also briefly cover a few areas of the Virginia Clean Economy Act of 2020 and mention some current VCEA implementation dockets at the State Corporation Commission. Next, Patrick will cover several renewable energy bills that passed this session, including bills pertaining to the Commonwealth Clean Energy Policy, nutrient credits, erosion and sediment control, Virginia Brownfield and Coal Mine Renewable Energy Grant Fund and Program, the greenhouse gas emissions inventory and regulations, and wetland and stream mitigation banks. After Patrick's presentation, I will briefly cover the permit by rule expansion to include energy storage systems, tax exemptions and revenue share amendments for energy storage, expansion of the siting agreements throughout the Commonwealth and expansion to include energy storage. And finally, I also cover a clarification to the third-party PPA Pilot Program. At the end, we hope to have time for a few questions, so please remember to send in your questions using the Q&A box. We have a lot to cover this morning, so I'll pass it off to Patrick to begin our presentation. Patrick?
Thanks, Brad. Go ahead and let's go to the next slide. So I just want to orient everybody because I realize we have folks joining from Virginia and outside of Virginia, but our 2021 legislative session was our short session. It's typically 46 days due to some procedural issues related to COVID-19. We ended up with a 48-day session, which combines a 30-day regular session and an 18-day special session. But essentially, they used those two mechanisms to get to the 48 days. And they adjourned in early March. Just for process issues, I want to make a note that as we go through this presentation, and Brad and I are covering a number of bills, today is actually the deadline for the governor to propose amendments or veto any bill. And so I want to make sure that everybody makes a note that on all the bills that we mentioned to double check whether the governor has signed, amended, or vetoed any bills. At this point, we expect all the bills to be signed, and many have. So I just want to make sure that I flag that process issue very quickly. But in Virginia, the makeup of our House, both the House and Senate are controlled by Democrats with a 55-45 majority in the House and a 21-18 majority in the Senate. And of course, our governor is a D. And our legislative session looked like many other states where our House and our Senate met virtually, or at least public participation was virtual. The main difference between the House and the Senate this year was the Senate actually chose to meet physically in person here in Richmond. The House met entirely virtually with legislators joining from their cars, couches, bedrooms, home offices, etc. I've already covered that the governor has until midnight tonight to propose any amendments or vetoes to bills. And if any amendments or vetoes are proposed to bills in the block that we're discussing today, those will be considered on April 7th next week during our one-day reconvene session. And the only other process thing I want to point out is that we're going to have another special session this summer. The ARP funding that came to Virginia, which is about $3.8 billion to the state, we have a provision in our budget to ensure that that money doesn't get spent unless appropriated during a special session of the General Assembly. All right, so I needed to orient everybody to where we are with our legislative session with this slide. Brad, let's go to the next one. I'm going to leave this up. I don't think there's anybody on this webinar, hopefully, who hasn't heard of the Virginia Clean Economy Act, which passed in our last legislative session. And everything that we're talking about today is standing on the shoulders of a very giant 2020 legislative session for the renewable industry. And just at a high level, it established for the first time in Virginia a renewable portfolio standard, which pushes Dominion to be 100% carbon free by 2045 and APCO to be 100% carbon free by 2050. The main mechanisms that are going to be used to get there, an establishment of a 16,000 megawatt solar and onshore wind requirement being in the public interest. This in the public interest phrase is the critical language that gets us past what has been some more critical review in the State Corporation Commission. The bill also advanced energy storage with a requirement of more than 3,100 megawatts in energy storage capacity. It established some energy efficiency standards and then advanced offshore wind in a big way with a 5,200 megawatts of offshore wind being in the public interest. So building off of this in 2020, and Brad, we can go to the next slide. The way I would characterize 2021 from an implementation standpoint is you've got a number of implementation dockets at the State Corporation Commission. Brad and I have listed those on this slide, so you can just take a quick note and snapshot of all of the regulatory implementation of the provisions that I just discussed on the CEA. And then Brad, we can go into the next slide. And these bills, which Brad and I are going to cover today, are really leaning in on some additional work that the General Assembly felt needed to be done. And a lot of these bills have been brought by the utility scale solar and wind industries to help the Commonwealth get to the goals established in the Clean Economy Act. So we're not taking these up in any specific order, but let me just start with the Commonwealth Clean Energy Policy, which I think from a high level, this bill does not have all that much in the form of teeth. But what it does do, and this is a little bit unusual in legislation in Virginia, is it sets out a number of goals and policy statements related to clean renewable energy and greenhouse gas emissions. Many of the targets and goals addressed in this bill far exceed the goals that are actually statutorily required in the Clean Economy Act. And like I said, it covers everything from environmental justice, electricity regulation, goals for carbon zero, advancement of everything related to clean energy in the transportation sector. So it's very broad reaching. I pointed out because, I think as long as we see the political climate stay particularly within control of the Democrats in Virginia, I think this is a good roadmap to items that you're going to see coming down in the next several years. So that's Senate Bill 1284. All right, next slide. All right, House Bill 1982. So one of the big areas in terms of implementation of the CEA with the 16,100 megawatt goal or mandate really by 2045, there's a ramp up to the RPS. There is a significant amount of solar going in the ground in Virginia. I think I saw one report that Virginia it was ranked number 4th in the country in terms of new solar facilities coming online in 2020. The real challenge in Virginia has been at the local level when it comes to getting panels in the ground. The local approval process has been I think local governments have been overwhelmed. And so a number of bills that we're going to cover today really address issues that we see at the local level and those that we see with stormwater and erosion and sediment control. And so this is one of those bills. House Bill 1982 authorizes a facility that's been issued a VCEA permit that regulates stormwater to acquire, use, and transfer nutrient credits for compliance with any waste load allocation established as an effluent limitation in its VCEA permit. Now, current law only allows for a facility registered under the industrial stormwater permit to use nutrient credits. So this bill really gives some additional flexibility for solar developers when going for stormwater approval processes. And just for those that aren't familiar with Virginia, the VCEA permits are required for all construction activities that result in land disturbance greater than 1 acre or for single family detached residential structures. So this is seeking to give some greater flexibility. Brad, let's go to the next slide. Okay, also continuing in the same theme for stormwater and erosion sediment control, Senate Bill 1258 seeks to address an issue where local governments have not been, in some cases, particularly well equipped to deal with erosion and sediment control plans. So what this bill does is allows a locality that does not operate a regulated municipal stormwater system, those are the MS4 systems, and for which DEQ did not administer a Virginia stormwater management plan, to notify the department if it decides to have the department perform the erosion and sediment control plan on behalf of the locality. So what this does is this, for those localities that don't have the resources and don't want to do this, they can move this process for erosion and sediment control plans to DEQ review. Now this is not done for free. There's there's a fee associated with the locality doing this that's passed on to the applicant. So make sure to, if you're working in a locality that's considering this, make sure to flag that there will be some fees associated with this. For those interested in more detail on how that's going to work, pulling Senate Bill 1258 will give you the additional detail. All right, Brad, let's go to the next slide. All right, Brad and I have already fielded a number of questions from developers on this. House Bill 1925 was carried by a Republican delegate from Southwest Virginia, Delegate Terry Kilgore. And what it does is it establishes what's called the Virginia Brownfield and Coal Mine Renewable Energy Grant Fund. Now, there was no state funding associated with this fund, and the bill has a provision in it that says that no allocation of funds shall be made unless federal funds are available to cover the cost of the allocation. So this is literally just a shell that's been put in place. It's not going to receive any state funding. It is there to accept federal funding if it comes down. Now, we don't know, there's certainly right now not any federal funding in this fund. We're not aware of any specific fund that is any specific funding from the federal government that's going to be appropriated, but it is there. And we can go to the next slide. We've got some details on how that money would be awarded and how it would be divided between previously coal mine lands and brownfield development. One of the things that will happen over the course of this summer is that the department is going to pull together stakeholders to develop a handbook for renewable energy and energy storage development on brownfields and previously coal mined lands. For those developers that are working in Virginia, you all are aware of some of the pushback you're seeing in localities when you're looking to take forested land and convert that to large solar projects, taking agricultural land. A number of organizations are pushing back on development in those areas, urging development in brownfields and coal mine lands. So certainly there's a lot of challenges with that, but hopefully we see some federal funding to assist projects in those areas. All right, let's go to the next slide. Greenhouse gas emissions inventory. I don't know that this bill is is super important for the solar industry or wind industry at this moment, but we wanted to flag it because for the first time, the Department of Environmental Quality, the Commonwealth, is going to be required through the State Air Pollution Control Board to do an inventory on greenhouse gas emissions every 4 years. So again, I don't know that there's anything actionable, but by merely measuring our greenhouse gas emissions, I think there is some expectation that future policy could be influenced by what these emissions inventories look like every 4 years. All right, let's go to the next slide. All right, wetland and stream mitigation banks, House Bill 1983. This is another bill that I think will provide some additional flexibility for developers when you're going for a water protection permit. Currently, the requirement when purchasing wetland and stream mitigation bank credits is that you have to be in, and I don't have the word up here, but the physiographic area, a specific area of your project. If you're going to purchase wetland and stream mitigation banks, you have to be in a primary area. And what this does is allows, in certain instances, for the developer to purchase credits from a secondary service area. There are some additional requirements related to cost and availability to be able to purchase in that secondary service area. There is a lot more to this bill than what we are showing on this slide. So I want to make sure for those that are working and interested in needing to purchase wetland and stream mitigation bank credits that they look at this bill, because there are a long list of requirements for purchasing in that secondary area. All right, Brad, let's go to the next slide. And I think this is where I hand it off to you.
Yep, thanks, Patrick. And so several of my bills that I'm going to cover today, I would consider that this is the year of energy storage, because a number of the bills include energy storage to existing bills that applied to solar. So to begin with, the first one, House Bill 2148, it expanded the permit by rule, also known as PBR statute, to include certain energy storage facilities. Just as background, small renewable energy projects is defined in the Virginia Code to include solar facilities with rated capacity not exceeding 150 megawatts. So those projects can seek a PBR from the Department of Environmental Quality rather than having to obtain a CPCN from the State Corporation Commission. And so as energy storage has become more prevalent, there's a question about the permitting of standalone and hybrid energy storage facilities. So HB 2148 amended the definition of small renewable energy project to include two things. One is standalone energy storage facilities that use electrochemical cells to convert chemical energy with a rated capacity not exceeding 150 megawatts. And then two is basically hybrid or solar plus storage, but it has to be, again, not exceeding 150 megawatts for solar or not exceeding 150 megawatts for storage. One thing also to keep in mind is that the DEQ will still need to promulgate regulations to implement these provisions. The bill provides that DEQ would have to have these effective no later than January 1, 2022. Also, just a quick note that the DEQ released proposed amendments to the PBR regulations early this month, and comments on those proposed amendments are due by May 14th, so just something to look out for on those as well. And until there's new regulations promulgated by DEQ to implement this new legislation, or for energy storage facilities that are either greater than 150 or don't use electrochemical cells, then the pathway is there's either a permit or CPCN from the State Corporation Commission that was referenced in their energy storage regulations, which came out in late December of last year. Now I'm going to cover House Bill 2006 and SB 1201. Again, another kind of adding energy storage. This is to the certified pollution control equipment and facilities tax exemption, which is in section 58.1 3660. For those that are developing solar projects in Virginia, you're probably very familiar with 3660 since it applies to solar. There was a question, however, about whether or not where energy storage fit and if it did fit within 3660. So this bill fixes that specifically to add energy storage systems, which is defined in the bill as equipment, facilities, or devices that are capable of absorbing energy, storing it for a period of time, and then re-delivering that energy after it has been stored. The tax exemption only applies to energy storage system projects greater than 5 megawatts and less than 150 AC. And also there's a step down for the exemption based on the years in service. So it's 80% for the first 5 years of service after commercial operation, 70% for the second 5 years, and then 60% for the remaining years in service. And then also, like solar, there's a sunset. The exemption does not apply unless an application has been filed with a locality, effectively like a land use application for the project before July 1, 2030. And then also, like solar, Department of Mines, Minerals, and Energy will be the state certifying authority for energy storage systems. So another part of HB 2006, SB 1201, is that there were several changes to the renewable revenue share statute, which is in 58.1-2636. The revenue share statute was enacted in 2020 and allows the locality pass an ordinance to assess a revenue share on certain types of solar facilities of up to $1,400 per megawatt. So this past session, the General Assembly amended the revenue share statute to include energy storage. So a locality could pass an ordinance to impose a revenue share of up to $1,400 per megawatt on storage capacity of energy storage systems. Also, there's another change that was an amendment to allow for an increase in the revenue share. Last year, there was some discussion about whether to allow the revenue share to increase over time. However, that was not included as part of the original legislation. So this session, they added to allow the revenue share to increase on July 1, 2026, and then every 5 years by 10%. And then that would apply to solar and also energy storage. And then just to note that they've grandfathered certain projects, those that had already filed an application with locality prior to January 1, 2021. And just another note too, that there's an interplay with 3660, the certified pollution control exemption, that if a locality adopts a revenue share to apply to energy storage, then energy storage systems in that locality greater than 5 megawatts would get 100% tax exemption under 3660. There were also several amendments to the solar siting agreement legislation that was also passed in 2020. The current solar siting statute only applies to certain solar projects located in opportunity zones, and HB 2201 and SB 1207 amends that to expand siting agreements to include energy storage projects and also to make them eligible throughout the Commonwealth, not just in opportunity zones. So an important takeaway from this new legislation is that any applicant for certain types of solar projects or energy storage projects must give the host locality notice of your intent to locate a project in such locality, and then to also request and try to negotiate a possible siting agreement. And I know a number of our land use attorneys are working on siting agreements as well as advising on this new legislation. Also, the legislation expands upon Virginia Code 15.2.2288.8, which adds that localities may accept cash payment for storage projects. The existing legislation was put in place for solar in 2020, and now it will allow a solar developer to negotiate compensation as part of approval of a land use application for such a project. Now, the last bill that I want to cover this morning is HB 2034 and SB 1420. And the legislation clarifies that the Renewable Energy Pilot Program, which is frequently known as the third-party PPA Pilot Program, to provide that both jurisdictional and non-jurisdictional customers may participate on a first-come, first-served basis. It's intended to clarify that the 40 megawatt cap in Appalachian Power and ODP's territories would apply to both jurisdictional customers such as C&I customers, and then also non-jurisdictional customers such as municipalities. So before we get to questions, I just want to mention real quick, a save the date for April 28th. We're going to do a webinar on the energy storage regulations that I mentioned earlier that passed in, they're actually adopted by the State Corporation Commission in December 2020. So it looks like we've got several questions. So I think the first question I see here is for Patrick on HB 1925. Is there any indication where the Brownfield Coal Grant Fund and program might get federal funding? Is the program only awarded to solar or also wind?
Yeah, no, good questions, Brad. So in doing a little more background research on this, one of the things that Virginia has received in the past is abandoned mine land pilot program funding. It's the AML pilot program, and it's money that comes down from the federal government to be used to reclaim abandoned mines. And of course, in Virginia, particularly in Southwest Virginia, we have a lot of abandoned mines. And so one of the hopes is that by setting up this specific fund for solar energy development, that if Congress did have additional monies available for abandoned mines and for brownfield development, that Virginia would be an attractive place to attract that money if they've got a fund that's dedicated and set aside and provides reassurances to Congress. I think especially with control of the White House and the House and the Senate with the Democrats, that the money that would go toward abandoned mines would be used for renewable energy development. So it's a little bit of a if you build it, they will come mentality associated with this new fund.
Okay, I think there's another question about how under HB 1925, the fund and program, how grants will be awarded. So it's first come, first serve, or competitive process.
Yeah, we don't know. There would probably be, I mean, there's some delineation between what money would go towards the abandoned mine lands and what would go towards brownfield development. And I think that's in the slide, the dollar split. But the Department of Environmental Quality, in conjunction with the Department of Energy, would probably develop some regulations. And I know from looking at past programs and grant funds where you have an overcommitment or really a surplus of applicants compared to the dollars that are in it, I think that you probably wouldn't split the money out equally on a pro rata basis. I imagine it would be competitive in nature, and this is me just speculating based on past funds that I've seen, but competitive in nature, but also some underlying policy considerations that that all the money doesn't go to one applicant, and potentially that all the money would be geographically dispersed, so not all within one locality, for example. But we're still going to wait and see what additional guidance comes down from Department of Energy, which formerly was DMME. And we didn't cover that bill, by the way, but for those in Virginia who are used to calling DMME the Department of Mines, Minerals, and Energy, there was a separate bill that we didn't cover that renamed that agency the Department of Energy. So, yeah.
I'll take the next question. Does the percent increase in the revenue share payments apply to solar projects too? The answer is yes on that question. Patrick, I think question for you, it says for the Wetland Mitigation Bank legislation, how is secondary service area defined? Is there any requirement to provide proof that no credits were available or credit price was too high?
Yeah. The word that I was struggling with before for the secondary service area is it's an area that's outside the primary service area, but within the same physiographic province in which the bank is located, and then any adjacent physiographic province within the same river watershed. So Virginia is split out into 5 physiographic provinces, which are just essentially regions of the state. And so in order to be able to purchase from that secondary service area, you'd have to, the burden is on the applicant really to show that no credits were available to purchase or that the credits exceeded a 200% price for that service area. But all of that, there's some additional detail in the bill that goes over those steps that it would take to get into that secondary service area.
Patrick, just one more question before we wrap up. When will these bills be effective?
Yeah, we have to go into each bill just to make sure, but the default effective date on all legislation that passes the General Assembly and signed by the governor is July 1, 2021. If somebody's got a specific question about a specific bill, we can certainly go into that and double check. But I am fairly certain that all the bills that we've discussed today have a July 1, 2021 effective date. Anybody on this webinar can certainly reach out and we can very quickly verify if you've got questions about that.
Okay, well, it looks like we're just about out of time. So I just want to give special thanks to Patrick for joining me today. Also want to thank all of you for attending and sending in your great questions. I know we did not have time to address all of them, so we'll follow up by email afterward. If you have any other questions or relating to the bills or anything else relating to solar energy storage development, please don't hesitate to give us a call. Thank you again for everybody for attending.